thank you, musical brother Owen, for all the things you do. We love you so much. You're our favorite brother. We love you so much. Not the brother with the fox or the brother with the other crazy stuff, but the musical brother. We love you so much, Mr. Owen. Mwah, 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 chef's kiss. Mwah. All right. So today we're talking about punitive remedies. Yep. We have one case and one case only, and then some statutes to read. If you remember our other day, we read the statute. It was the thing. So be prepared for that. So punitive damages. Exxon Shipping Company versus Baker. U.S. Supreme Court 2008 statute, or case rather, okay? So this is, if you remember, this is the Exxon taker Valdez. In 2000, it spilled out, and there was all the fucking, like, the little seagulls who were all covered in oil. Everybody ran on there, and they got, like, Dawn dish detergent. Like, oh, let's save the seagulls. I'm like, oh. This is the same tanker. The super tanker Exxon Valdez ran aground in Prince William Sound, spilling millions of gallons of crude oil. Joseph Hazelwood, the ship's captain, was a relapsed alcoholic who had dropped out of treatment. I mean, homie was drinking. There was evidence that his superiors knew that he was a relapsed alcoholic. He stopped going to the meetings, you see, and he's drunk driving a tanker. Bad shit happens. Yeah, there was also evidence that before coming on board the night of the disaster, he drank 5 double vodkas. So that, if my math is working, that's equal to 10 vodkas. 5 double vodka, 10 vodkas. Well, why not? The ship left the normal channel to avoid ice. 2 minutes before reaching the last point for turning back to the channel, Hazelwood put the ship on autopilot. He left the bridge and he went to his cabin, leaving instructions for the third mate, not the first mate or the second mate, but the third mate, and the helmsman to take their turn. Both regulations and universal practice require that his presence, meaning drunky vodka boy's presence on the bridge. Among other things, he was the only officer who was licensed to navigate Prince William Sound. So in naval stuff, right? There's like, okay, so there's a body of water and like it's there, and like you have to be licensed to navigate it. So if you're like, hey, like we're off the coast of California, I've never been here before, you're not licensed to navigate that. You need somebody who's done it through practice, right? And you can't just be like, oh, I'm just going to do this now. That's how people die in fucking ocean disasters. So the only guy who was licensed to do it was doing vodka off the bow, and everybody else was in charge, and he was down below freaking getting crunk. So that's what happened. All right. The autopilot. Oh, he's on autopilot. So he hit cruise control. Cruise control, go. The autopilot setting increased the difficulty of the turn. For reasons unknown, the mate and the helmsman missed the turn and ran aground. So they're like, we don't know what's going on. We don't fucking know. They ran aground. Hazelwood then tried to rock the ship off of the reef. So now Hazelwood has the controller, and he's like, Had he succeeded, if he did what he was trying to do correctly, which he didn't do, then a whole bunch more oil than was spilled would have been spilled. So a good thing he didn't do that. But 11 hours after the spill, Hazelwood's blood alcohol level was measured at 0.06. Exxon disputed the validity of the test. Extrapolating backwards, an expert testified that his blood alcohol level would have been 0.24 at the time of the spill. So 0.8, legal limit, 8, even me can do the math. 24 divided by 8 is 3, so he would have been 3 times the legal limit. That's how math works. At the time that he crashed the fucking thing into the fucking reef. Anyways, Exxon spent $2.1 billion on cleanup efforts. Cleaning them baby seals with that Dawn, right? And paid $25 million criminal fine and $100 million in restitution in the criminal case. Criminal restitution is a form of compensation to victims. Exxon paid $1.3 billion in restitution cases and compensatory damages in civil settlements within the United States, Alaska. Why does it say the United States and Alaska? Alaska is part of the United States. Fucking communist judges. And private plaintiffs who sued other cases. Alaska is part of the United States. So what is the United States and Alaska? The case consolidated class actions under the general maritime law on behalf of the commercial fishermen. Native Alaskans, okay, that's different, and local landowners. Exxon paid about $500 million in compensatory damages to those three classes, mostly in partial settlements and some pursuant to the jury verdict. So, Alaska or Exxon settled with a lot of these people prior to the whole thing going to court, right? The case consolidated, instructed to consider the reprehensibility. The reprehensibility is so evil. Those oil-toting motherfuckers of defendant's conduct, the financial condition, and the magnitude of the harm, and any mitigating facts. The jury awarded $5 billion in punitive damage against Exxon and $5,000 against Hazelwood, the drunk captain. $5 billion with a B against Exxon, and 5,000 with a TH and 1 comma before the zeros against Hazelwood. Ninth Circuit twice vacated and remanded on constitutional ground. The district judge thought the verdict justified an entered judgment for $4 billion, so $1 billion less on the first remand, and $4.5 billion, so he upped it again on the second remand. There you go. On the third appeal, the Ninth Circuit reduced it to $2.5 billion. I mean, at that point in time, it's just pennies. You find that in your Exxon can find that in their couch cushions. Who knows? Ridiculous. Anyways, the Supreme Court unanimously rejected Exxon's argument that the Clean Water Act preempts a claim for punitive damage under the general maritime law. It was evenly divided with respect to Exxon's argument that it could not be held vicariously liable for punitives for Hazelwood's. Okay, remember vicarious liability? You're the guy at Walmart who's charged mopping the floors. You fuck up, you don't mop the floors. There's like rotten, like raw egg, not rotten, but raw eggs on the floor. Here comes Mary Lou, whatever, and slips on her ass, boom, on the floor. You make $4.55 an hour. Mary Lou Freebush is not going to sue you. She's going to sue you, and through the vicarious liability of your superior company, respondeat superior, vicarious liability, same thing. Sue Walmart for your action, right? So same thing. Captain Hazelwood's drunk driving his boat. Runs aground. So we're going to sue Exxon, his employer, through him. Right? That's the whole thing. All right. Exxon argued that the punitive damages were excessive. That $4.5 billion, maybe a bit excessive. Even as reduced by the Ninth Circuit, the general maritime law is federal law made by judges in the manner of a common law court, subject to congressional authority and legislature which it chooses. So this is not a constitutional law case. Rather, the Supreme Court functioned much like the Supreme Court of a state, reviewing a verdict in common law terms. Because the court rarely does this, it had to select to create the standards that would apply. Okay, so now Supreme Court's like, we don't fucking usually do this, but we're doing it in this case. Because of that, we need to make shit up to make it make sense. So now the Supreme Court is going to make shit up. So stand by. It's going to be great. It's going to be great. The modern Anglo-American doctrine of punitive damages dates back to at least 1763, where a pair of decisions by the Court of Common Pleas recognized the availability of damages for more than the injury received. Wilkes v. Wood. An English court. Crikey, mate. An English court. I don't know where Australia now. It's an English fucking court, and it says it's from freaking 1763. It's a while ago. In Wilkes, one of the foundations of the Fourth Amendment exemplary damages award against the Secretary of State responsible for the unlawful search of John Wilkes' papers. I wonder if no, it's not John Wilkes Booth. That's not John Wilkes Booth. Not the dude who shot Lincoln. Nope. That was later. Not the same guy. I was just curious because John Wilkes Booth. The mind boggles. Nope. Anyways, they awarded him a spectacular 4,000 pound. 4,000 pounds. Pounds sterling. British money. Awarding damages beyond the compensatory was not, however, a wholly novel idea. Even then, legal codes from ancient times through the Middle Ages, through King Arthur's fucking times, having called for multiple damages for certain especially harmful acts. But punitive damages were a common law innovation, untethered to strict numerical multipliers, and the doctrine promptly caused Atlantic to become widely accepted, or it crossed the Atlantic, and it was widely accepted in American courts by the middle of the 19th century, which is also when slavery was going on. So maybe we should look at that as quite a great thing, eh? Maybe not, maybe, I don't know. B. Early common law cases offer various rationales for punitive damage awards, commonly including punishment for past wrongs and deterrence of the future wrongs. A third historical justification was the need to compensate for the intangible injuries, compensation which was not otherwise available under the narrow conception of compensatory damages prevalent at the time, citing from Cooper Industries Incorporated via the Leatherman Tool Group. Hey, Leatherman, they make those cool knifey things. That's awesome. Fuck those guys. But see Anthony Seabook, what did punitive damages do? Kai Kent, sounds like a Chinese communist, 2003, probably Chinese communist, arguing that punitive damages have never served the compensatory function attributed to them by the court in Cooper. The consensus today is that punitives being punitive damages, are aimed at not a compensation, but principally at retribution, meaning, fuck you, you did a bad thing, we're going to hurt you by making you pay money. This consensus informs the doctrine in most modern American jurisdictions, where juries are customarily instructed on twin goals of punitive awards. See California jury instructions. We knew these assholes in California the last 3 days. It says, you must now determine whether you should award punitive damages against defendants. The second example of my way of punishment, because we're California. Fuck it. The prevailing rule in American courts also limits punitive damages to cases where defendants' conduct is outrageous. Owing to gross negligence, willful, wanton, or reckless indifference to the rights of others, or behavior that is even more deplorable than that. Which I don't know what really is. The only more deplorable behavior that's like effing children. And so, yeah, fuck them. Don't want to do that? Fuck them. Burn the stake. Under the umbrellas of punishment and its aim at deterrence, degrees of relative blameworthiness are apparent. Reckless conduct has not intentional nor malicious. Blameless conduct is neither intentional nor malicious. I'm not sure that's true, but whatever. Yeah. So a blameless conduct is not intentional or malicious. It was not undertaken with an intent to injure. So if I'm just like, dude, I have a new car, and I just drive over your foot, and your foot's broken, I'm not like, fuck your foot. It's not. It's different, right? That's the whole thing. Regardless of culpability, however, heavier punitive awards have been thought to be justifiable when wrongdoing is hard to detect, increased chances of getting away with it, or the value of the injury and the corresponding compensatory award are small. And with a broadly analogous object, some regulatory scheme provides by statute for multiple recovery in order to induce private litigation to supplement official enforcements that might fall short of that was intended. Basically, like, if there's some law that says you can get this money and like it's like not very much money, but we want people to not do the thing. So say somebody, like, there's a chemical company that moves in behind you and starts dumping toxic waste in your backyard, and you're like, hey, chemical company, stop fucking doing that. And they're like, no, make us. And you're like, okay, I'm going to sue you. And this court issued an injunction that says, stop dumping chemical waste in the backyard. They're like, okay. And they're like, also, all my children have 5 arms growing out of their back now. They're like, well, we don't have a standard damage thing for like children with arms growing out of their backs. So maybe we want to punish the company dumping chemicals a lot harder because we don't want 5 arms growing out of children's backs. So we're going to fine you $3 billion, even though, I mean, it's not, I mean, maybe those kids could be great at fucking ping pong. Who knows? It doesn't matter. The point is that the compensatory damages for the wrongs that are caused does not equal to the total amount of damages awarded because we want to punish them on top of it. And so those kids will be baller at rock, paper, scissors, but we can't count that in the damages. Maybe good guitar player could play fucking drums and guitar at the same time. That'd be a thing. C. State regulations of punitive damages varies. A very few states award them rarely or not at all. Nebraska bars punitive damage entirely. Nebraska, no punitive damages, only compensatory. So if you're a fucking multinational evil corporate, Elon Musk, Nebraska, you can blow half of the fucker up. No punitive damages. Think about it. Nebraska bars them entirely. Constitutional. 4 others permit punitive damage only when authorized. So also consider Consider Louisiana, Massachusetts, Washington, and New Hampshire. Okay, don't consider Washington or Massachusetts. So consider Louisiana and New Hampshire. Really. Michigan courts recognize only exemplary damage supportable as compensatory rather than truly punitive. Connecticut courts have limited what they call punitive recovery to the expense of bringing a legal action, including attorney's fees. So basically, like, you can't get a punitive monetary award in Connecticut, but they'll pay your legal fees, which is rare in American courts. As for procedure in most American jurisdictions, the amount of the punitive award is generally determined by a jury in the first instance, and that determination is then reviewed by the trial and appellate courts to ensure that it's reasonable. As from a Pacific Mutual Insurance versus Halsip Supreme Court case from 1991. Many states have gone further by imposing statutory limits on punitive awards in the form of absolute monetary caps. For example, Virginia caps it at $350,000. And there's a maximum ratio of punitive to compensatory damages of 2-to-1 in Ohio. So in Ohio, if you get $350,000 in compensatory damages, you can then get punitive damages up to $700,000 in Ohio. I think Florida is a 3-to-1 ratio. I'm not sure what other ones are. It says, in fact, or frequently some contribution of the two. There is a 3-to-1 ratio in Alaska and in Florida. Hey-o! The states that rely on a multiplier have adopted a variety of ratios, ranging from 5-to-1 to 1-to-1. So they can go up to, it doesn't say. I can look. I would wager it's probably a 3-to-1 state. But here, hey, chat, if you want a homework assignment, you can Google punitive damage ratios, West Virginia or Kentucky, and you can figure it out yourself. Despite those limitations, punitive damages overall are higher and more frequent in the United States than they are anywhere else. Yeah, we fuck people over in the United States more than Canada does. Yeah. Hey, hoser. All right. And some legal systems do not decline to recognize punitive damages themselves or refuse to enforce foreign punitive damages as contrary to public policy. Basically, like, Canada's like, you can't penalize Canadian people in a punitive way. We're doing compensatory. Like, okay, you have a truck in Canada. It's like running over the freaking bridge over Niagara Falls. It jumps off the bridge and like kills 2 tourists, right? Be like, hey, hosers, that's not very good, eh? And like they're gonna sue them for like whatever the damages are to people. Like, hey, Johnny was hurt, eh? And then freaking Johnny and Jeffy were hurt, eh? And they both had like wages they could have earned, right? And so they have like lost economic wages. And you can recover economic wages, but you can't do punitive damage. Like, hey, fuck you, Canadian company, who are gonna charge you on top of the wages they lost and all the freaking other things. we're going to make you pay another $250,000, and Canada does not recognize that, right? And so we can't make them pay the extra punitive damages. Only the United States does punitives in that way. That's what I'm trying to say. All right. American punitive damages have been the target of audible criticism, meaning very loud criticism, apparently, in recent decades. But the most recent studies tend to undercut much of it. Okay. A survey of the literature reveals that the discretion to award punitive damages has not mass-produced runaway awards. So, like, people aren't going cray-cray with it. Well, sometimes they do, but, like, apparently not everybody is. Who knows? Stop. Stay still. All right. And although some studies show that the dollar amounts of punitive damages awards are growing over time, even in real terms, the most accounts for median ratio of punitive to compensatory awards has remained less than 1-to-1. Nor do the so for example, in the Take Care of Maya trial, the Maya Kowalski trial in Florida, right? I'll get to that question in a second, chat. But so let's think about the Maya Kowalski trial in Florida. Girl, medical kidnapping, torts for battery, torts for false imprisonment, torts for wrongful death for the mother, right? And so they awarded her something in the order of $211 million in economic, so lost wages, lost growth, etc. Something like 60, combining the non-economic, which is pain and suffering, and the economic damages were like $261 million they awarded her. And then they give $50 million in punitive damages. So even in that case where the hospital was a bunch of douchebags and screwed her over, right? The punitive damages were only $50 million, and the non-economic and economic damages were over $216 million by themselves. And the court upheld that. So we're talking punitive damages as to punish the people who did the wrong from doing the wrong, right? So the punitive damages, even though they're big, 50 million is a lot of money, right? But it's a lot less than 216 million they already awarded her. So that's kind of how it falls out. So, yep. All right. Nor does the data substantiate a market increase in percentage rates in case of punitive awards past decades. The figures thus show an overall restraint and suggest that in many instances a high ratio of punitive to compensatory damage is substantially greater than necessary to punish or deter. So basically, the court's saying here is that, like, even in cases when they use punitive damages, right, to deter the action, the juries usually go with punishing them through economic damages before they even get to punitive. So the court is worried here about runaway punitive damage. Like, oh, we'll give you $1 of monetary damages and give you $300 billion of punitive damages. And the court's saying that could happen, but it's just not happening like right now. That's just not what's happening in real life. All right. The real problem, it seems, is the stark unpredictability of the punitive awards. Courts of law are concerned with fairness and consistency, and evidence that the punitive awards are infrequent fails to tell whether a spread between high and low individual awards is acceptable. The available data suggests it's not. A recent comprehensive study of punitive damage awards by juries in state civil trials found a median ratio of punitive compensatory damages that was 0.62-1. So meaning that for every dollar you get from compensatory damage, meaning you've been wronged, you've been hurt, you lost economic thing, you have pain and suffering, right? For every dollar you get from that, the jury only awards 62 cents of punitive damages. So the court's trying to say, well, that's not so out of whack. We're not so worried about that now because it's not that high, right? Yep. But the mean ratio was 2.90-1 and a standard deviation of 30. Okay, so numbers are a bitch, right? And so there's a standard deviation of 13.81. So essentially, even though, okay, so let me break this down. So there's 100 cases, right? And in each of these 100 cases, they gave punitive damages, right? And in 89 of the case, or let's say 80 of the cases, right? They gave punitive damages of $100, right? So then you have, you get a mean, right? Is you divide 100 cases by $100 for all the cases, right? So for those, you have a 0.8 mean, right? Or median, rather. Median, right? And then all of a sudden, the last 20 cases are like $300 million of punitive damages for all these last cases, right? So you have this huge standard of deviation then, right? And so all of a sudden, that median and that mean jumps a lot. So even though like the mean would stay low, the median would jump, and then the freaking like average or the standard deviation would jump, because you have a very few high line cases or have the tail go up on the award level, right? Whereas most of them are low level. I hope that made some sense. It probably didn't, but that's why lawyers don't do math. But it makes sense somewhat. Anyways, Theodore Eisenberg, who sounds reputable, sounds like a guy I would trust with numbers, in his paper, Judges, Juries, and Punitive Damages, explained that the empirical analysis, good, even to those of us unsophisticated in statistics, that's me, the thrust of these figures is clear. The spread is great. The outlier cases subject defendants to punitive damage that dwarf the corresponding compensatory. That's what I was saying. The distribution of awards is narrower, but still remarkable. Among the punitive damages assessed by judges, the median ratio is 0.66 to 1. The mean ratio is 1.60 to 1. And the standard deviation is 4.45. Other studies of some of the same data show that fully 14% of the punitive awards in 2001 were greater than 4 times the compensatory damages. Okay, so in that case, right, in these simple cases we're talking about, like, so the punitive awards were 4 times the compensatory. So okay, let's say that you got, you're a Door Dasher. Your job is you fucking drive a bicycle to give people their meals, right? And as you were doing that one day, a car hit you and broke your right leg, right? Like you pinned you against the car and broke your leg. So now you can no longer do your DoorDash job because you need 2 legs to pedal your bicycle. You can't do that, right? So compensatory damages would be to pay you fully for your medical bills to heal your leg all the way through. Compensatory damages would be to pay you for the lost wages that you couldn't do peddling your DoorDash while you were recovering, right? And any pain and suffering you would have to have. So those are economic damages. The pain and suffering is not economic, but it's still compensatory. So that would, you're like, oh, I'm so sad I broke my leg. I'm so sad I can't DoorDash. Wah. So you get some money too, right? So say that all that together, the medical, the wages, everything comes to $100,000. Let's just say, hypothetically, right? So the jury then, according to this survey, would award 4 times that in punitive damage, meaning you get $100K for your medical, your lost wages, and whatever else, right? But the punitives would come in and they'd be, okay, you get that $100K, and we're going to give you $400K on top of that as a punitive damage to stop Chatty Cathy, who ran into you while she was talking to her mom about the cheerleaders exposition, while she was soccer driving kids or whatever, right? Would award that against her to like, bad Chatty Cathy, don't chat while driving your car. So that's how that would happen. So that's what they're talking about. Does that make sense, chat? Somewhat, chat? Hopefully. All right. The range of variation may be acceptable or even desirable if they resulted from judges and juries refine their judgments to reach a generally accepted optimal level of penalty deterrence. So, okay, so basically they're saying, like, yeah, this would make sense. If all these awards came to, like, there was, like, a concurrence, like, okay, and this sounds weird, but the way it would be is like, okay, look, in order to stop Chatty Cathy from fucking talking on her cell phone while she's driving her soccer mobile around, the courts say $200,000 is a great amount of damages to give her. And everybody in New York said, yeah, $200,000 sounds great. Boston said $200,000 is great. Louisiana, $200,000 sounds great. Georgia, Wyoming, $200,000 sounds great. And there's some agreement as to the amount, right? That somehow, and this is ridiculous, but like somehow the sweet spot, the freaking baby bear, just right Goldilocks amount is $200,000 to deter Chatty Cathy from running into DoorDash people on her car. And that was somehow universally agreed upon. Okay. But the problem they're saying here is there's no universally agreed upon amount. And so, therefore, the levels of punitive damages don't reflect the outcome we want punitive damages to have in the judicial system, because punitive damages are meant to deter future conduct that's bad, right? And so if you don't have something that's agreed upon, then it's hard to say that it's actually deterring the conduct, right? For example, there's leading cases where a $4 million verdict by an Alabama jury noted that a second Alabama case, which was very strikingly similar, produced a comparable amount of compensatory damage, but there were no punitive damages at all. So, meaning there was an Alabama case that had very similar facts, like homeboy got ran over in Biloxi, Alabama. Other cases, homeboy got ran over in Birmingham, Alabama, right? And homeboy in Biloxi got $100,000 settlement for compensatory damages and $4 million in punitives. Homeboy in Biloxi got $100,000 of compensatory damages, same as homeboy in Birmingham, but got 0 punitive damages. And so we have no idea. And the Supreme Court of the U.S. even says, we are aware of no scholarly work pointing to consistency across punitive awards in cases involving very similar claims or identical circumstances. So there's no way to make this work across jurisdictions, right? That's the difficulty. So we're going to read E here, and I think we'll go. Yeah, we'll just read E. E. The court's response to outlier punitive damages awards has thus far been confined the claims at the constitutional level. So we only deal with constitutional claims. Today's inquiry differs from due process review because the case arises under a federal maritime sailors jurisdiction, and we're examining the verdict and exercise of federal maritime common law authority, which proceeds unless should obviate, meaning get rid of, any application of constitutional standard. Whatever may be the constitutional significance of the unpredictability of high punitive awards, this feature of happenstance in tension with the function of the awards in punitive, just because the implication of unfairness that was an eccentrically high punitive verdict, carries in a system whose commonly held notion of law rests on a sense of fairness in dealing with one another. Thus, a penalty should be reasonably predictable in its severity, so that even Justice Holmes's bad man can look ahead with some ability to know what the stakes are in his choosing his course of action or another action, even for the bad man. See Oliver Holmes, The Path of the Law, Harvard Review, 1897. Way back when. And when the bad man's counterparts turn up from time to time, the penalty scheme they ought to face or ought to threaten them with a fair probability of suffering in like degree when they wreak like damage. The common sense of justice would surely bar penalties, and reasonable people would think excessive from the harm caused by these bad men and these bad circumstances. So I've really talked through most of the analysis already. We kind of already know where it's going and why. So there you go. That's remedies, punitive damage, limits, and caps. Tip your bartenders, tip your waitresses. Thank your mothers for bringing you to this earth, because God knows it was tough work. Take good care. God bless you. Good luck and good night.